On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
Well, 2 weeks ago we had your annual top 10 list as far as looking at cases throughout 2021, and this is the list now, the almost top 10 that didn't quite make it up into that top 10 list.
Yeah, that's right. I started going through this in my 3 most recent blog posts, and I probably have 4 or 5 more because I've listed out about 18 additional items that I think are really important, but not quite as big nationally as the top 10 that we discussed last time. So this is going to, if you're following me on my blog, this is going to continue probably for at least another week.
All right, well, let's get to it. And the first case involves the Endangered Species Act, and and specifically looks at involving what the Biden administration is looking at on proposed regulations that would expand the definition of habitat.
Yeah, this is a big issue, not as much in Kansas, although we have had issues with Topeka shiner and I'm drawing a blank on it right now. What's that bird that's been an issue, Greg, over the past few years? Lesser prairie chicken. Lesser prairie chicken. So Kansans have experienced this issue, but where most of your listed either endangered or threatened species are located are in Florida and Texas and California. Those are typically the states that have the most listings. And of course, the problem you get into, or the concern that agriculture has, is what if these things show up on my private property? Can the federal government regulate my land use activities to protect the habitat of these species? And the answer under the Endangered Species Act is yes, they can. Now, in the Trump administration, some of the regulations that the U.S. Fish and Wildlife Service uses were modified to factor in more economic concerns when designating habitat and making sure habitat was really essential for the conservation of the species. Because what had happened prior to that was that you'd get these critical habitat designations, which mean land use restrictions for private landowners, that would cover the historic range of the species, even though the species had not been spotted in certain areas of that range for decades. And there was a case that went to the Supreme Court in 2018, and they said, they peeled that back, and they said, no, critical habitat actually has to be habitat. You can't include areas that at one point in time, decades ago, were part of the range, but are no longer, where the animal or bird or plant species, whatever it is, has not been spotted there for decades. So that was a big win for landowners. And then the regulations were changed to fit with what the U.S. Supreme Court said. Well, the new administration came in and on the very first day said we're going to change that rule. And or on the first day after the rule went into effect, the new administration changed the rule, and now they published, USFWS has published proposed rules that would rescind the Trump administration critical habitat rule. And U.S. Fish and Wildlife Service says they don't agree that areas have to be excluded from designation when the costs exceed the benefits, which was another part of the Trump rule, if it won't result in the extinction of a species. So we can expect further issues for private landowners going out into the future because really putting a number on this, according to U.S. Fish and Wildlife Service data, about 80% of habitat of protected species are on privately owned land. So it is a big issue.
And the U.S. Circuit Court of Appeals just heard a case on an appeal from back in late August?
That's right, yeah. So we've got some further litigation that continues to go on in this.
All right, let's go on to the next one. This looks at some other issues, and it really has to do with estate planning. And if I say this name wrong, please, this is the Warne case, but it looks at, never really rushing through the process when you're doing estate planning.
Yeah, that's the key point of this, and I'll spare people the technical details of this. If they want to read that, they can read it in my detailed blog article. But what it is a couple the basic facts are they started investing in real estate in the 1970s, and they kept acquiring that property throughout their lifetimes, their balance of their lives. Well, one of them gets ill. They start to do some pretty aggressive estate planning with their planners, and they're pushing to get things done. And they transferred ownership of the properties into 5 separate LLCs. They got leases that are involved. It gets really complex. Plus, they threw in a family trust. And the end result of this is that the drafting that was done on their behalf cost the family a $2.5 million charitable deduction because the language in the wills and the trusts and the LLC agreements was incorrect. And this is not something that was a brand new result. We've known that this would be the result of this type of estate planning for over 30 years, about 35 years. There was a significant U.S. tax court case in the late 80s, and the IRS followed that up with private letter rulings in the 1990s. But it points out to me that we don't want to wait till the last minute to do estate planning. That puts the planners in a tough position because they rush the process. And sometimes in rushing the process, you can overlook technical things. And this was a big error in this situation. And I think, Greg, it also points out that there is no single estate plan that will fit for everyone. And so estate planning is a process. It has to take time, and it's something you want to work on as time goes on and as things change in your life, and goals and objectives might change, asset values change, and even the law changes. So we want to take a kind of a slow, thoughtful approach to estate planning. This is one of those cases that just illustrates to me the process got rushed, the planners missed something, cost the family huge.
Is that a common mistake in the aspect that some think that, well, so-and-so did it this way or so-and-so did it this way? That sounds like a good idea.
Well, I've seen that problem crop up. Of course, I've dealt with farm and ranch families for 30 years doing these things, and ultimately the client makes the call, makes the decision. But it's the planner's job to lay out what all of the options are and what you think is the best option for them, and then let them choose based on full information. Now, some people do get, they do get puzzled by why their plan is different from the neighbor down the road, even from an income tax planning standpoint. But there's so many different factors. They're in a different income tax bracket. They get higher business deductions if they put up a gold-plated glass line facility. You won't do that. You won't get that same benefit because you're in a lower tax bracket. We can get the same thing from an estate planning standpoint. Their family situation might be different. Maybe they have a child that is interested in taking over the farming operation. Maybe you don't. Maybe you have multiple kids that want to. The families that have 6, 7, 8 kids with 6, 7, and 8 different ideas as to what might happen and what they want to see happen with the farming operation after mom and dad are gone is the most complex and the most difficult. Those situations take a lot of time to get the planning straight, and that's also hard for clients to understand. And, of course, the longer the time frame, the more costly things become in terms of fees. But you see cases like this, they rushed the process and they lost a $2.5 million charitable deduction for the estate because the process was rushed.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, joins us. And Roger, the next case is talking about compensation for the bankruptcy trustee, which they are entitled to one, but there's distinctions between a Chapter 12 filing of bankruptcy and a Chapter 13 bankruptcy filing, especially when it comes to the fees.
And, Greg, we may have something brewing here that's going to go to the 10th Circuit Court of Appeals. And, of course, Kansas is in the 10th Circuit, and so that would be applicable to us. And ultimately, it may be something that will have to be addressed by the Congress. And in fact, the bankruptcy court in this case, the district court in this case, did point that out, that there may be something that Congress wants to take a look at. Well, what the issue here is involved a debtor that filed a Chapter 13. Now, that's a different reorganization section of the code. 12 is a reorganization section just for farmers. But farmers can also file a 13. They don't get the special tax treatment as they would in a 12 if they file a 13, and some of the other rules are different. And this focuses on one of those other rules. Here you've got a debtor, they propose their reorganization plan, they make about $30,000 in planned payments to the bankruptcy trustee. All your payments have to go to the trustee, and the trustee then disperses to creditors. But the trustee is allowed, under bankruptcy law, a 10% cut of the fees that trickle through the bankruptcy trustee's hand. So if $30,000 is to go to creditors, it goes through the trustee, and they're going to take $3,000 out of that. And so then $27,000 is going to be left to go to creditors. That's the way that works. And that's what happened in this situation. So the trustee pays the legal counsel for the debtor about $20,000 of that, and then about $7,500 was for property taxes in this case. And the trustee paid himself about $2,600 in partial satisfaction of that 10% fee. And the debtor wanted a return of that amount that was paid to the trustee, that the trustee paid himself, arguing that, well, my plan did not get confirmed, so there's a Chapter 12 rule that says that, trustee, you don't get to keep the fee. Well, 13 is not like that. And the court ultimately said here, trustee, you can't keep that fee. You're not going to get paid in this situation. And this is different than a Chapter 12, where you do get to get paid in these situations where the debtor's reorganization plan is not confirmed. Now, the district court in Colorado looked at this and they said, well, yeah, that's the way Congress wrote this, but they expressed concern that the trustee in these situations may not actually get paid for their efforts, and said, this is something Congress may want to take a look at. This is a big deal because it also influences the type of filing that one makes. Are you going to file a Chapter 13? Or are you going to file a Chapter 12? Because if the trustee doesn't get to keep the fee, that's going to come back to you as the debtor. In certain situations where tax is not a major concern, a farmer may want to opt for a 13 in this situation rather than a 12. I'm going to keep an eye on this one to see what happens in 2022. If this goes to the 10th Circuit, we're going to have a rule change in Kansas. Perhaps the Congress will take a look at it, but I kind of doubt it. Bankruptcy things are back burner issues. They're not high-profile, sexy things that the Congress likes to deal with until they have a big bankruptcy bill, for example, or there's a major problem that's out there. But this is one that's significant enough for bankruptcy attorneys in counseling their clients that it can make a difference in the right case.
And Roger, the last case we want to talk about, once again, goes back to estate planning, the complexity of the estate planning, but how they, through each process of estate planning, how things must be done right as well.
Yeah, this is an estate planning case involving an estate of about $80 million. And so you've got to make sure that things are done correctly in these situations. And this one involved the creation of an LLC, had a family dynasty trust that was involved. And what they're trying to do is make gifts to the balance of the family members in a tax-efficient manner. Well, this was happening in 2012, late 2012, and we had a similar situation at the end of 2021. Up until about mid-December. And that was, there was a fear on the part of many clients that the Congress was going to change the rules and drop the federal estate tax exemption or change the capital gain tax rules or change corporate tax rules and create a higher tax for them. And particularly what they were thinking in 2012 was the same thought process that was going on last year by many people, and that is, well, if that exemption is going to come down to $5 million, as the talk was last year, and effective in 2022, then I need to do some estate planning right now. And again, this is the problem that you can get into with estate planning, where you rush the process and you're not thoroughly reviewing documents. You don't have an estate planning team put together where there are multiple eyes looking at things, and you just go too fast and you make a mistake. And when you're dealing with an $80 million estate, a small mistake can cost easily seven figures. So again, we've got this type of a mess. It's just not. It's not a good idea to do estate planning either by waiting when you have health emergencies that arise and then you do something. But the same thing is true for significant life events other than health, or when you think the law is going to change. This is something that practitioners need to be in constant contact with their clients, constantly reviewing files, to see if any proposed changes in the law are worth looking at now and not waiting until it's really too late to do an effective estate planning job. And this ended up, again, what was done, costing the family a lot of money, millions and millions of dollars, because the plan was done incorrectly, and then somebody died. But this is a problem, Greg, that's also, I have to put some of the blame on Congress. Constantly changing the laws. What we face as practitioners, whether it's on the income tax side or on the estate planning side, the business planning side, is you get every election, it seems like, where the policy ideas change. They want to change the tax code. And it's not just a little tweak here or a little tweak there. It's a massive overhaul, it seems, about every 4 or 5 years. That is horrible on tax practitioners. It's horrible on clients, because then we've got to make massive planning changes, massive shifts in what we're trying to do. And you get into messes like these 2 cases we talked about this morning, where you end up rushing the process, you're not thinking things through, and then the rules don't change in the way you anticipated them, and or you made a mistake, and now you've got a major, major catastrophe financially for the family that's been created. So I put some of the blame on, maybe a lot of the blame on Congress in constantly changing the rules, and we have to keep up with them, and that makes it very, very difficult on practitioners.
And then, and the point being, too, in so much of this, planning, but being careful and having the qualified professionals really look at this throughout the entire process.
Yeah, again, I'm going to come back, and your last word there is the key. Estate planning, business planning is a process. It's not something that you get up in the morning and say, well, I'm going to do my estate plan today. No, that's something that has to be considered over a long period of time, a long window. Now, things can happen while you're in the estate planning process, and I understand that, unexpected things, and you may not get done what you need to get done, but it is a process. There needs to be a team involved more than just the attorneys. You want to get your tax professionals involved, your financial planners, your life insurance people, all of those to put what we hope is a bulletproof plan together.
Indeed, indeed. All right, Roger, as always, appreciate it, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program this morning here on 580 WIBW.